Are there any other votes? Announce the results.
Ayes 134, noes 0.
The bill is passed. Mr. Morelli.
Thank you, Ms. Speaker. If I could give the next 4 bills that I'd like to take up in the following order. Calendar number 194 on page 14 by Ms. Glick, followed by calendar number 241 on page 17 by Mr. Thiel. Once that's concluded, we'll take up calendar number 243 on page 17 by Ms. Simon. And then in this grouping, we will then take up calendar number 459 on page 35 by Ms. Paulin.
The clerk will read.
Assembly 4958, Calendar 194, Ms. Glick, an act to amend the education law.
An explanation has been requested. Ms. Glick.
Certainly, Ms. Speaker. The bill would prohibit licensed mental health practitioners from engaging in sexual orientation change therapy with patients under the age of 18. This is a practice that has been discredited. It is emotionally and mentally damaging. It has been rejected by the American Psychological Association, the American School Counselor Association, as well as the American Academy of Pediatrics, the National Association of Social Workers, the American Counseling Association's Governing Council, and the American Psychoanalytic Association, among many others, including the Academy of Child and Adolescent Psychiatry. So a broad spectrum of professional associations and organizations have deemed this to be undermining of the self-confidence and the emotional stability of young people who are struggling with coming to terms with their sexual orientation. In many instances, it's not the youngsters, but rather their parents that are having trouble. And so their parents are perfectly free to go and seek counseling in order to deal with what they view as a problem. But the youngsters, it would deem it to be professional misconduct to engage in these types of activities with minors.
Ms. Corwin.
Thank you, Mr. Speaker. Would the sponsor yield?
Certainly.
Sponsor yields.
Thank you, Deborah. Under current law, the way the law is written right now is if a mental health professional is found to go against or do something that defies what the scientific data supports out there, does the process allow for them to be charged with professional misconduct now?
I believe that the State Education Department generally acts on the basis of complaints. And so if somebody felt that they were a mental health counselor or really almost any licensed professional was engaged in some activity that they were concerned about, an investigation would ensue. And certainly in the wide range of the various types of licensed professionals that exist, there are both scope of practice and standard practices within the profession. And if somebody is outside of those parameters, which are developed based on the common practice, which hopefully is based on scientific and professional experience, then yes, they would be deemed to be operating in misconduct. But there's a wide range of options faced by the state education department as to what kind of action they would take when somebody is engaged in. This does not specify that somebody's license has to be immediately revoked or anything like that. It, again, leaves it up to the department, but it would say that it's professional misconduct, and then they would have to do an investigation and determine whether or not to what degree and what sanction they would impose.
Sure, and I guess that's why I just wonder why we need the bill at all, because shouldn't the process already be working in that respect? I mean, you enumerated in your bill all the scientific evidence, which is quite extensive. There's quite a bit of scientific support saying that these therapies are very damaging to young people. It seems to me that the professional organizations should basically be outlawing it themselves, and state ed should be saying this doesn't work.
Well, the reason that we've done this, we've had a hearing, and right now what happens is if there are individuals who feel like they're uncomfortable, it generally occurs, not with the youngsters so much as parents, and we had parents who came to a hearing and said, this was somebody who was licensed by the state of New York, so I thought it was okay. So this would provide a clear demarcation that would say to the public that this is a line over which people should not cross.
Okay. And as far as parental involvement, because we're talking about children under the age of 18, they could be very young children who might be seeking help from a mental health professional. And out of practice, parents are generally involved in that therapy plan. Would this bill in any way prevent parental involvement or parental decision-making in other therapies outside of sexual orientation?
No, this would simply make it clear that if someone wanted a mental health counselor, and there are some organizations, one in New Jersey, which the state of New Jersey has deemed it, this bill was passed by both houses and signed into law in New Jersey by Governor Christie. So there was an organization in New Jersey that was promoting itself, and they have been charged with consumer fraud because it is determined that the issue of coming to terms with whatever emotional discomfort people have around the issue tended not so much to be with the gay individual, but rather family members. And so we had parents who came, and one mother said, well, I thought my son was fine, but my husband was very upset, and he insisted that my son go to this therapy, and I saw my son's behavior deteriorate. He became more depressed. He became isolated from his friends. He didn't want to go out of the house. But I didn't know any better because this was somebody who had a New York State license. So this is why we think the bill is important.
Okay. And the bill is specific to children under the age of 18. So
Right.
if there's an adult who is seeking help from a mental health professional and they come and say, I don't want to be gay, help me to change my orientation, just saying that an adult has the authority to make those decisions for themselves, would this prevent a mental health professional from providing that therapy to an adult?
No, unfortunately, we allow charlatans to perpetrate fraud upon adults.
All right. Very well. Thank you, Ms. Glick.
Thank you.
Thank you, Mr. Speaker.
Mr. Walter.
Thank you, Mr. Speaker. Will the sponsor yield for a
Will
quick
you
question?
yield, Ms. Glick?
Certainly.
Ms. Glick yields.
Thank you, Ms. Blick. Does this bill in any way interfere with a parent or a child's ability to seek counseling from a priest or a pastor or a rabbi or anybody?
Absolutely not.
Great. Thank you very much.
Read the last section.
This act shall take effect January 1st.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 102, noes 19.
The bill is passed.
Assembly 6269, Calendar 241, Mr. Thiel, an act to amend the real property law.
An explanation is requested, Mr. Thiel.
Thank you, Mr. Speaker. This legislation deals with circumstances relating to homeowners in mobile home parks or manufactured home parks in New York State. Specifically, the legislation provides a judicial remedy for rent gouging in mobile home parks and manufactured home parks. I mentioned the term homeowners, so the issue may be, well, if they're homeowners, what's the rent? How does this get involved? And that this legislation really deals with the unique circumstances that homeowners in mobile home parks find themselves in, and that is they own their home, but they do not own the land on which the home sits, and they have to rent that land from the park owner. So there's a substantial portion of their housing costs that they're not able to control. Now, what makes their circumstances unique, obviously different than landlord-tenant, if you don't like your rent, you can find another apartment. Certainly different than traditional home ownership. But what is also unique with regard to mobile home park home ownership is a great proportion
One
of
minute, Mr. Thiel. Ladies and gentlemen, we're on debate. I understand you're all very important. You got a lot of things you need to say, but say it afterwards or somewhere other than the chamber. Please.
Thank you, Mr. Speaker. What is also unique with regard to home ownership and mobile home parks is, one, they are disproportionately senior citizens. Two, in many, many communities, certainly the case on Long Island, but many places across the state, they're the only one of the few affordable housing options that are available for people out there. And thirdly, there are very few locations. In fact, there's been a decline in the number of sites where mobile home parks where homeowners can look to site their homes. So it puts them in a position where they really don't have a lot of bargaining power with the park. So because of that, they are particularly vulnerable to rent gouging. If you increase the rent by 15, 20, 50%, you have senior citizens who just don't have an option, and many times they will end up having to forfeit their house. So what this legislation does is it creates a judicial remedy. To be able to take advantage of that remedy, it has to be your primary residence. To be able to take advantage of this also, you would have to have a rent increase proposal that is above the cost of living. There is a presumption in the legislation that it's irrebuttable presumption that a rent increase is justifiable when the amount of the increase does not exceed the tenant's pro rata share and operating costs and property taxes. So even if it's above the cost of living, if it fits that requirement, it is found to be reasonable. And then it provides judicial standards for a court to consider in determining what would be a justifiable rent versus versus rent gouging. So in essence, it provides a remedy in court. The last thing I should mention also is that this is local option, and that is for this remedy to be available for a mobile home park resident, the local county would have to pass a local law authorizing this remedy to be available. So it is really local home rule where local counties can decide for themselves whether or not this remedy should be available.
Mr. McKevitt,
Sir, will the sponsor yield for a few questions, please?
will you yield? Sponsor yields.
You know, it's interesting you mentioned the argument about being a local county's home option because this bill is now irrelevant from the Nassau County portion because there are no more land for manufactured home parks. There was one last one left in Syosset, and that actually closed a few weeks ago. But I think that just gives more impetus to your argument that there are not many options. Again, for those people in Syosset, when eventually they were told, we want to put this property over to development, you have to find another place. There's no place for them to bring the mobile homes.
And that's why this isn't a traditional market situation where, you know, with a landlord and tenant, at least you have some bargaining power. These people have less bargaining power in that situation.
Right, exactly, because you own a unit, but there are very few places, even within Long Island or many portions of the state, where you can actually go to another community. You may have to go 75, 100, 200 miles in order to go and find another place.
You may have
put
to
that
go
home.
as far as Mr. Palumbo's district to find locations.
Might as well be a different state as far as I'm concerned someday. So, but just to go into some of the specifics of your bill, you know, some people have issued the bill because it may be a form of rent control. Again, it's a rent control in a very specific instance. But just go through a couple of the details in the bill. On page 2, around lines 32 through 38, you talk about the fact that a tenant can make the prima facie case is if the increase in rent exceeds the consumer price index. And obviously, these days, consumer price index can be a very, very low amount. And I'm just wondering with some of the logistics, because when you go on to talk about the increase in rent on lines 38 to 39, talks about includes all cost increases, including rent, fees, charges, assessments, and utilities. As you know, there is a creature very dear to your heart known as the Long Island Power Authority, which time to time will put in a rent a fuel surcharge from time to time, which exceeds that amount. So let's say you are the owner of the manufactured home park and you rent it out, and let's say the consumer price index is 0.2%, but let's say LIPA puts in a 3% fuel surcharge that year. How does this part of the bill work then? How does it operate?